Welcome to Civil Procedure. As we continue our discussion of subject matter jurisdiction, this is video 4 of 5, where we are introduced to the Grable test. When we began our module on subject matter jurisdiction, we were clear as to what the question was. How can we get into federal court? What types of cases does the federal court have the authority to hear? We've seen two main pathways into federal court. The first is diversity jurisdiction, where the parties are completely diverse and the amount in controversy is satisfied. The second pathway is federal question jurisdiction, which requires that a federal issue appear on the face of the plaintiff's well-pled complaint. But here's the problem. Not every case that should be heard in the federal form fits in one of those two very nice, neat boxes. For instance, what happens when the lawsuit is based on a state law cause of action, but deciding that state law cause of action depends on interpreting a federal statute? The Supreme Court answered that exact question in the case of Grable and Sons Metal Products v. Daru Engineering in 2005. Grable shows us that the well-pled complaint rule, while the baseline for federal question jurisdiction eligibility, it is not, however, the end of the story. There is a narrow, carefully limited category of cases where state law claims carry enough federal weight to justify a federal forum. After Motley, the federal courts had a clear test for federal question jurisdiction eligibility. Federal question jurisdiction was said to exist only when a federal issue appeared on the face of the complaint. But in practice, we understand rarely are things that clean or that simple. Some cases arise under state law, but turn entirely on the interpretation of federal law. With that, let's jump in to Grable and Sons to see how the courts have determined we should draw that line. The story of Grable and Sons begins not in federal court, but it begins in state court in a state law cause of action entitled Quiet Title. The short story is that Grable, the owner of Grable and Sons, did not pay his taxes for some period of time. The Internal Revenue Service, in turn, seized Grable's property and sold his property to satisfy his tax debt. The buyer of Grable's property was Daru Engineering. They took title at a tax sale. 5 years later, Grable sued Daru in Michigan State Court to quiet title to the property. When you take property you'll understand more about quieting the title. But in short, it is a type of lawsuit that is filed when there's a dispute over who owns a piece of property. In its state court complaint, did you hear state court? In its state court complaint, Grable alleged that the IRS's failure to give him notice in the exact manner required by Section 6335A rendered the tax sale invalid, and as such, it rendered Daru's record of title of the property invalid. So I know you've read the case, but what's happening is Grable didn't pay his taxes. There is a federal statute that allows the Internal Revenue Service with notice, right? With notice to seize property, sell your property to satisfy your tax debt. Now, what does that notice look like? If you went to the statute, it's actually 26 USC section 6335A. If you want to go look at the statute is expressing an intent to give notice to the person who is entitled to that notice. Well, the IRS interpreted that to be something less than personal service. And Grable is saying, no, 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 no certified mails, no substituted service. Personal service means in my hand, and the IRS didn't do that. So here's the doctrinal tension. There was no federal cause of action that was claimed in this lawsuit. There was no well-pled complaint by the plaintiffs because Grable did not file this lawsuit in federal court. So the federal statute is not plainly on the face of the petition because it was filed in state court. It is a state law claim. Go back to the Motley case where Motley was suing, seeking specific performance of a contract. That's a state law claim. Now, again, Motley's distinguishable because Motley actually filed their suit in federal court and Grable filed his suit in state court. But make sure that you are looking at these differences and these similarities because they matter, right? So Grable sues Daru in Michigan State Court with a claim of quiet title, which is a property suit, which is a state law claim. Now, what happens? Grable removes the state lawsuit to federal court, citing 28 USC 1331, and the gloves are off. This is the core question that Grable forces us to confront. What do we do and how do we classify a state law claim that carries within it an embedded federal law question? Can I get in the federal courts? Well, Daru said, absolutely, allow me to assist you. Here's the notice of removal. So let's walk through these facts. Grable owed back taxes. IRS seized his property. IRS sold his property. Daru purchased the property. Under 26 USC 6335A, the IRS was required to give Grable notice of seizure by personal service or certified mail. In this case, IRS sent it certified mail. 5 years later, as we've stated, Grable filed a state court quiet title action arguing that the IRS's failure to give personal notice rendered the seizure and the subsequent sale void. Not voidable, but void. Daru removed the case to federal court under 1331, arguing that even though the claim was created by a state law right, its resolution necessarily depended on interpreting a federal statute. What are your thoughts? This is how the Supreme Court chose to handle the case. Not yet. We have to go through our fact element map. Again, not going to go through all of it. You have the opportunity to do that at your leisure, but let's walk through at least a couple of them, right? First, the IRS seized Grable's property to satisfy unpaid federal taxes. Yeah. The entire enforcement process was governed by federal law. That immediately establishes a federal dimension, right? The element here is that the case originated from a federal statute, right? Let's look at how the court analyzed that. The IRS's authority derived entirely from federal law, making the underlying federal procedure central to the resolution of this state quiet title claim. Let's look at one more. Let's look at the second one. The IRS provided notice by certified mail as permitted under 26 USC 6335A. Grable argued that the statute required personal service. The adequacy of notice, certified mail versus personal delivery, right, was the federal question embedded within the state quiet title claim? Well, what did the court say in its analysis? It said the interpretation of statute section 6335A was necessary to decide who held valid title. The federal issue was necessary and actually disputed. Was necessary and actually disputed. Let's do one more. Let's just do the third one. Although the claim itself arose under state quiet title law, the dispute could not be resolved without answering a question of pure federal law. The court emphasized that even though the cause of action was state created, the federal issue was necessary and dispositive. Okay, I see a test in our future. Can you see the test coming? I see a test in our future. Before we can really digest Grable, we have to remember what Motley taught us. In Louisville and Nashville Railroad Company versus Motley, the Supreme Court drew a clear jurisdictional boundary under the Judiciary Act of 1875, right? The predecessor of what is now 28 USC 1331. In Motley, the court held that a case arises under federal law when the plaintiff's own well-pled complaint shows that the federal law creates the cause of action, or forms an essential element. That means the federal issue must appear on the face of the complaint, and it can't be buried, right? It can't be buried in there. It can't be a defense. It can't be an anticipated defense. It has to say its name. The Motley's fatal mistake, if you remember the case, that was just the last video, was pleading a state law contract claim while merely anticipating that the railroad may rely on a federal statute as a defense. That's not enough. So Motley gives us the baseline rule of restraint. Remember, we're exercising restraint. We are narrowing the scope, right? And that baseline rule of restraint is the federal question must be visible from the plaintiff's initial pleading. Importantly, this is not a constitutional limit on judicial power, because we know that for all intent and purposes, the constitutional interpretation of arising under really doesn't have any limits. Right? Fantastic. That's what Motley gave us. A century later, we get Grable. The court acknowledged that Grable did not fit within the classic Motley framework. The claim was based entirely on a state quiet title law, yet its resolution turned entirely on the interpretation of a federal tax statute. The question was this: can a lawsuit that arises under state law nonetheless also arise under federal law when a federal issue lies at the heart of the state law claim? We know the answer. The Supreme Court answered yes, but only in exceptional cases. It announced what we now call the Grable test, a four-part inquiry asking whether the state law claim, one, necessarily raises a federal issue. See that word? Necessarily raises a federal issue. Two, the federal issue is actually disputed. Three, substantial to the federal system, right? The resolution of that federal issue that is actually disputed must be an issue that is substantial to the federal system as a whole, not just substantial to the parties of the lawsuit, but to the system, right? And four, the resolution of that state claim by a federal tribunal does not upset the federal state balance, which means it does not result in federalism. This doctrine, sometimes called the embedded federal question doctrine, carves out a very, 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 very small but critical refinement of Motley. It ensures that federal courts can resolve cases where the meaning of federal law itself is what is at stake. And remember, in Motley, it was Justice Marshall who said that is one of the vital reasons that the federal courts exist. One of the reasons that the federal court exists is to resolve matters just like this. So, what is our 3-point issue statement in Grable? Under 28 USC 1331, does a state law claim arise under federal law when resolving that state law claim necessarily requires interpretation of a disputed and substantial question of federal law? Tell me more about this embedded federal issue. Well, let's set up the question. Let's walk through the doctrine the Supreme Court gives us in Grable, and let's see if we can get a better understanding of what an embedded federal issue actually looks like. The framework of the embedded federal issue doctrine defines when a state law claim may, nonetheless, this is a state law claim, but it may, nonetheless, arise under federal law for purposes of 28 USC 1331. But the court makes it clear it is not enough that a federal statute or federal regulation is mentioned somewhere in the pleadings. That is not what we're doing. This is a conjunctive test. All 4 conditions must be met. First, the case must necessarily raise a federal issue. What does that mean? In other words, the court cannot resolve the plaintiff's claim without interpreting the federal law. So let me say that with some clarity. The court cannot resolve the plaintiff's state law claim without first interpreting federal law. If the case can be decided entirely on state law grounds, there's no federal question jurisdiction. Copy that and pin that, because you will see that very idea exercised in Gunn v. Minton. Copy that and pin that, because you're going to see that again. Let's move to number 2. Second, the federal issue must actually be disputed. The parties must genuinely contest what the federal law means or how the federal law should be applied. A hypothetical or a conceded federal reference does not get us federal question jurisdiction. And that should make some sense, right? Because subject matter jurisdiction is not something that we can agree upon. Either the court has it or it doesn't. And so it would make sense then that we shouldn't be able to concede a federal reference if we're trying to establish federal question jurisdiction, right? Third, the federal issue must be substantial to the federal system as a whole, not just important to the parties in this particular case. The court looks for issues whose resolution affects the actual operation or uniformity of federal law nationwide. That supports what John Marshall said in Motley, right? The purpose of the federal courts. And finally, the exercise of federal jurisdiction and the resolution must be consistent with federal-state balance. Recognizing jurisdiction by the federal courts cannot upset Congress's intended allocation of judicial responsibility. In other words, it must not transform ordinary state disputes into federal law cases. So, Grable gives us a narrow test, a small but significant doorway through which certain state law claims with an embedded federal question may be allowed to enter federal court under 28 USC 1331. So let's apply it. Let's take some facts from Grable and apply it to this four-part test and see if our resolution is the same as the United States Supreme Court resolution. So, step one. In the Grable framework, we have to ask whether the claim necessarily raises a federal issue. In other words, this is the question that we're asking. Can the state court resolve the case without the need for the interpretation of federal law? If the answer is no, that is, no, the state court cannot resolve the quiet title without first interpreting the federal statute, then we are on our way, right? Here, the answer is no. Grable's entire quiet title claim hinges upon whether the IRS followed the notice procedures required for 26 USC 6335A. That's a federal statute for the Internal Revenue Service, which is a federal agency. The quiet title claim rose and fell on how 26 USC 6335 was going to be interpreted. If the IRS complied with that federal statute, then Daru owned the land, which means the quiet title is moot. If the IRS did not comply with that federal statute, that means that their seizure and sale was void, which means Daru is going to lose. There is no independent state ground resolution of this case without interpreting that federal statute. So, step one is about necessity of the resolution of the federal statute. Here, step one is satisfied. Let's go to step two. This statute in question, the federal statute in question, must actually be disputed by the parties. It's not enough that a federal law is mentioned, right? The meaning or the application of that federal law must be contested. Well, what's going on in Grable? In Grable, the parties absolutely, squarely disagree about what 26 USC 6335A means. Absolutely. Grable says it means personal service. That's what the statute demands. Daru says certified mail was sufficient. So there's an actual dispute on the interpretation of what that federal statute requires. What does that mean for us? Step two is satisfied. Nice. Love a checklist. Love a checklist. Let's move on to step three. In step three, what is being tested is the substantiality of the federal statute as it relates to the federal system. The IRS cannot function if its statutory procedures mean different things to different courts in different states. There must be some consistency. There must be some uniformity. The court stressed in Grable that consistent interpretation of federal tax law is not only important, but it's vital to the United States revenue system, because the notice requirement in 26 USC 6335 affects the integrity of tax collection nationwide. The resolution of that federal issue is substantial to the federal system, not just to the litigants. So it's a big deal. Step 4, our last step. The fourth prong asks whether exercising jurisdiction would disrupt the balance between federal and state judicial responsibilities. The court in Grable reasoned that quiet title actions are typically matters of state concern. But this one's exceptional. Federal tax seizures are uncommon, and federal notice procedures have broad federal implications, right? Because of that reason, because of the need to have uniformity in the interpretation of this federal law, resolution of this case isn't going to upset the federal government, state government, or federal court, state court balance, right? It's not going to take cases from the state court and give some preference to federal court. There's no competition here. Nobody's losing anything by the federal court bringing some uniformity and some consistency to this case. So step 4 is also satisfied. What's our holding? Federal jurisdiction was upheld. The removal was sustained. We haven't gotten to the merits yet. We haven't gotten to the merits yet. We are just trying to get into federal court and not get kicked out. We started in state court. We were removed to federal court. And had it been up to Grable, we would have been kicked out of federal court back to state court. But because of the necessary need, redundant, but important, right? Because this statute is it's so intertwined, right? It's the heart of the state law lawsuit. Federal court, that's a reasonable place for this to be decided. So the Supreme Court unanimously held that jurisdiction was proper in the federal court. The quiet title action depended entirely on the meaning of federal statute 26 USC 6335A. That issue was necessary. It was actually disputed. It was substantial, and the resolution of that federal issue would not upstate, would not unbalance that balance between state courts and federal courts. The court concluded that since all 4 Grable factors were satisfied, removal to the federal court was proper, and the removal was affirmed under 1331. So in short, Grable stands for the principle that a state law claim may arise under federal law if it necessarily raises a substantial, actually disputed federal issue appropriate for federal resolution. What does my rule of law look like now? Under 28 U.S.C. 1331, a case arises under federal law when the plaintiff's properly pled complaint either establishes that federal law creates the cause of action on its face, that's Motley, or shows that the plaintiff's right to relief necessarily depends on the resolution of a substantial question of federal law. That's Grable. Thoughts? Ideas? No, right? Think about it. It actually makes sense. Under 1331, most federal questions cases, pretty straightforward, right? Motley is the baseline. And at first glance, Grable wouldn't qualify. But because the plaintiff's claim necessarily turned on that federal statute and whether or not the IRS complied with that statute, the court treated this as an arising under case. What are your takeaways? We've said them several times already, right? Federal jurisdiction under 1331 can extend beyond cases where federal law creates the cause of action. In rare circumstances, a state law claim may arise under a federal law claim for these reasons. Yeah. From Grable, we go to Gunn because we know that Grable gives us a very narrow alternate pathway to get to 28 U.S.C. 1331. Gunn is going to show us exactly how narrow that pathway is. With that, I look forward to seeing you in the next and last video under the subject matter jurisdiction federal question module. See y'all next time.